Hello, my name is Andrew Flushy, and I'm a Virginia traffic attorney. If you were in an accident in Virginia and received a reckless driving charge, please know that you're not alone. In most accident cases in Virginia, where there's any kind of significant damage, someone is going to receive a ticket. And in a lot of those cases, it's going to be a reckless driving ticket. Simply because in many cases, there's not a specific traffic violation that the officers can point to say, well, you did this wrong. And so they charge you with the catch-all reckless driving, either under the reckless driving general rule, which says that any person is guilty of reckless driving if they basically endanger life, limb, or property of anyone, or under the reckless driving, failure to maintain control of your vehicle charge, which says that you're guilty of reckless driving if you have inadequate brakes or if you don't maintain proper control of your car. So those two statutes are kind of catch-all statutes that can be used in an accident case. And you have to know, first of all, that the officer doesn't have a lot of discretion. A lot of times it's department policy or some kind of policy to write the ticket. And a lot of times there's just not anything else that applies other than reckless driving. And so they kind of stuck to they have to write that. Now, the judge, though, has a lot of discretion. There's one statute that the judge might be able to use called improper driving. And what that says is, where any person is charged with reckless driving, if it's a minimal kind of case, the judge can reduce it to improper driving, and that's just a traffic offense. It's just a low-level traffic infraction. If you have a Virginia license, it's only 3 points, the lowest level of points, and it goes away in 3 years. And so it's a very, very minimal offense to be convicted of. But what does it mean to be charged with reckless driving for an accident? What that means is that the Commonwealth is going to have to prove that you were in fact reckless. There's law in Virginia under the Powers case that simply says that the happening of an accident does not mean it's reckless driving. The Commonwealth has to point to something you did or didn't do that you should have done that's more than, basically you didn't use ordinary care and you did something that was either truly reckless, like driving kind of crazy, or you did something, neglected to do something that was reckless. The law does recognize that accidents do happen, and not every accident is someone's actual criminal or traffic fault. Now you still may be civilly liable, but that's a whole nother ball of wax. What we're talking about is whether or not you could be found guilty of reckless driving or even improper driving. In quite a many accidents, the person may be charged with something, but the Commonwealth may simply not be able to prove what happened. Just because your car went off the road on a county road late at night doesn't mean that you did anything wrong. It could mean that there was something in the road that you tried to avoid. It could mean there was a mechanical defect of your vehicle, and both those things would not necessarily be your fault, and you might be able to be found not guilty. It all depends on the facts of your case, though, and so it's definitely something you want to talk to a traffic attorney about. If you have a case around Fredericksburg, Spotsylvania, or Stafford, I'd love to talk with you about your reckless driving accident case.